Hello friends, welcome once again, and let us take up our next landmark Supreme Court case, the next one in our journey of exploring the history of the Supreme Court of India. Is one of my favorite unknown cases. We love a lot of cases uh, whose judgment has been given by the Supreme Court. Most of them are very well known. This is one of those lesser known cases and extremely complicated cases, and the title itself will raise a few eyebrows and will make you pay attention a little bit more. State of Tripura versus the province of East Bengal. Obviously, East Bengal is a part of Bangladesh today, and the judgment, when it was given 4th of December 1950, East Bengal province was part of East Pakistan, a part of the sovereign nation of Pakistan. And how then could this be a party to a suit in India? How could the province of East Bengal be adjudicated upon by the Supreme Court of India? That in fact is the issue before us. That in fact is the issue before the Supreme Court in this particular case, and that is what makes this such an interesting landmark judgment. 4th of December 1950 is when the court gave its decision, and it is the last of our 1950 cases, the fifth case rather, that we have considered in this journey. And it began in a very fascinating fashion. I must warn you upfront that it has a very convoluted history. The facts of the case are slightly complicated, and it is going to take a lot of work from us to understand what all happened during this. First of all, why is this a landmark case at all? And if it is landmark, why haven't we heard about it? This is not a case which is likely to be referred several times, because these kind of issues only occurred during the time of partition of British India into India and Pakistan, the two dominions at that time, and therefore it is very unlikely that we ever have to refer to these cases. But then why are we considering it as a part of our journey into the discovery of the history of the Supreme Court? Why is it one of the important cases to be decided during the first 75 years of our Supreme Court? Well, this is why. It deals with issues due to property transferred during partition, and there are so many statutory provisions that are in consideration during the adjudication of this case. Interestingly, the Constitution of India does not focus at all in this discussion, which is perhaps understandable. Why would the Constitution of India have anything to do with something that happened in East Pakistan? Well, then, why would anything happening in East Pakistan have anything to do with us at all? Why would the Supreme Court get involved in something like this? It is because of these enactments. The Bengal Agricultural Income Tax Act of 1944, when East Pakistan had not been created, when East Bengal was a part of Bengal, was a part of British India, came under the jurisdiction of the Calcutta High Court. And then, of course, the Indian Independence Act, which formalized the independence of India as well as the partition of India into the two dominions of India and Pakistan. And then several orders that were passed under that legal instrument, Indian Independence Act. Even the Government of India Act features somewhere during this adjudication. The Civil Procedure Code of 1908 also features somewhere during this adjudication. It is a very interesting, convoluted, complicated journey of this particular case, and it all got kicked off on the 1st of April 1944, when the Bengal Agricultural Income Tax Act of 1944 came into force. Right away, we are surprised by this very fact. Agricultural income tax. It seems an anomaly, it seems an aberration to us in India, because we, of course, do not tax agricultural income. Agricultural income is free of any income tax. But that was not the case, quite evidently, in at least the province of Bengal, at least in 1944. The act applied to the entirety of Bengal as it then was, which included East Bengal, as well as, and this is crucial, as well as every ruler of an Indian state holding lands within the territory of Bengal. The term Indian state here refers to princely state. All those tiny kingdoms, some of them tiny, some of them quite extensive, which were not a part of British India but were still under the rule of the British. They were not directly ruled by the British, but they were instead subsidiaries of the British, which is why after the events of 1857, the Governor General of India, also known as the Viceroy of India. As far as British India was concerned, he was playing the role of Governor General. As far as the princely states of India was concerned, he was playing the role of the Viceroy, or the Deputy of the King, or the Crown, Viceroy, Royal Deputy. So there existed these 500 odd princely states. Some of them had land which was part of the province of Bengal, and this Bengal Agricultural Income Tax Act of 1944 attempted to tax the agricultural income of the produce that was generated on the lands in the province of Bengal, whether or not they belonged to private individuals or belonged to some princely state or the other. And the state of Tripura was one such princely state, which had an estate named Chakla Roshnabad. And this Chakla Roshnabad estate received a notice sent by the Agricultural Income Tax Assessment Officer of the Dhaka range to furnish the returns for agricultural income for the financial years 1944 and 45 as well. This notice is what kicked off the events. 12th of June 1945 is when this notice was challenged by the ruler of the princely state of Tripura, who owned this Chakla Roshnabad estate. This ruler, Maharaja Sir Bir Bikram Bahadur, approached the local court, which happened to be the subordinate court in Dhaka, contesting the validity of the notice sent by that agricultural income tax assessment officer of the Dhaka range. And he also challenged the proposed assessment by the province of Bengal. The issues were quite obvious, quite evident. The Maharaja claimed the provincial legislature of Bengal did not have any authority to impose any tax, not just agricultural, but any tax on any income of an Indian state or of its ruler. The province of Bengal only had jurisdiction over the British India ruled part of the province. That was the first claim. The second claim related was that the Dhaka range income tax officer had no authority or jurisdiction to issue any notice to any manager of any estate which lied outside British India, which lay outside British India. So quite a straightforward complaint really by the Maharaja. But even while the suit was being decided, or even before it was decided, a couple of things happened which further complicated the matters. First of all, the Calcutta High Court transferred the suit from the court of the first subordinate judge of Dhaka to the court of the subordinate judge in Alipur. Alipur is, of course, a part of Calcutta, one of the most plush and posh areas of Calcutta today, of Kolkata today. And the reasons behind this are not mentioned anywhere in the judgment, but we can hazard a guess, probably something to do with where the plaintiff, the Maharaja of the state of Tripura, was likely to appear every once in a while. Was he likely to appear in Calcutta or in Dhaka? And he successfully convinced the Calcutta High Court probably to transfer the case from Dhaka to Alipur. Either way, that is where the rest of the events took place. The Alipur subordinate judge heard the rest of the case. Meanwhile, in June 1947, Maharaja Sir Bir Bikram Bahadur passed away, and therefore his son took over as the ruler of the state of Tripura, as well as the plaintiff in this particular suit. This, of course, doesn't happen logically or anything like that. There is a legal provision which decides this, that is Rule 1 to 6 of Order 22 of the Civil Procedure Code 1908. We are not going to go into the details of the Civil Procedure Code or of Order 22 or of Rule 1 to 6 of in this order. You will just have to take my word for it for the moment, because the case, I assure you, is complicated enough anyway. So as I said, this just doesn't happen logically or simply out of out of events. It has to be specifically adjudicated upon, and that is done under the Civil Procedure Code Order 22, that the plaintiff's son takes over the suit, provided that the right to sue has not expired along with the plaintiff. In this case, the right to sue existed because the plaintiff's son would anyway have to be subject to the income tax assessment. Secondly, 18th July 1947 is when the Indian Independence Act of 1947 was passed. This act, of course, ended the British sovereignty over the subcontinent. It also divided the subcontinent into two sovereign nations, two dominions to begin with, until they got their constitutions into place. These two dominions were, of course, India and Pakistan, and the princely states had the authority to join either of them or to remain independent. The state of Tripura decided to join the dominion of India. Meanwhile, part of this was, of course, the partition, and the partition happened in two areas of the subcontinent. On the western side, West Pakistan was created out of Punjab and Sindh and Balochistan and the northwest frontier province. And on the eastern wing of the subcontinent, East Pakistan was created out of the provinces of Bengal and Assam, which were partitioned. So the province of Bengal, which was the respondent or the defendant in this particular suit, that itself ceased to exist, just like the poor Maharaja who passed away. The province of Bengal was also extinguished, you might say, and it was succeeded, just like the Maharaja was succeeded by his son. The province of Bengal was succeeded by two provinces, West Bengal, part of the dominion of India, and East Bengal, part of the dominion of Pakistan. In this particular case, since it was the Dhaka income tax officer who had set about these events through a notice, and since Dhaka was a part of East Pakistan, so the province of East Bengal would succeed in this particular suit, or at least that was the argument made. Just like we had Order 22 of the CPC, which ruled on who would succeed the plaintiff, there was a piece of legislation on who would succeed for the defendant. Meanwhile, in December 1947, a few months after the partition, the income tax officer of the Komila range in East Bengal ordered the imposition of income tax on the plaintiff, on the state of Tripura. That income tax was, this is the tax, okay, this is not the income. So you can imagine how much the income was, much larger than that, about 3 times larger than that at least. So the tax for the year 44-45 was 1,79,000 rupees 848 and 12 annas and 0 paise. And for the year 1945-46, it was 1,34,326 rupees and 7 annas and 0 paise beyond that. Incidentally, we should spend a moment on that. For example, in that second amount, if well, maybe it's easier in the first amount. If 78 paise was the assessment, then it would be 12 annas and 3 paise. So the dash 12 dash 0 would have become dash 12 dash 3, 12 annas being equal to 75 paise, if you can remember that. Anyway, significant amounts were under discussion is the point of noting these over here in this slide. And so whoever was going to be a part of the suit was going to dispute this for sure, and that was the preliminary objection raised by the province of East Bengal, that we will not be a part of this because the Alipur court, which was hearing this suit, no longer had the jurisdiction and no longer had the jurisdiction over this case because East Bengal was not a part of India, and Alipur court was of course under the jurisdiction of the Calcutta High Court, which was under the jurisdiction of the Federal Court of India at that time. Remember, we are still in 1947. The Constitution of India has not come into force. The Supreme Court of India has not been created. So the Calcutta High Court reported to, as it were, the Federal Court of India, which no longer had jurisdiction over East Pakistan. That was the preliminary objection raised before the Alipur court. The Alipur court was going to have to decide upon its own jurisdiction. This happens once in a while, and we will look at several cases of this later on, especially when arbitration cases come into the picture. But for the moment, let us just assume that every court has the authority to decide its own jurisdiction. And the jurisdiction of the Alipur subordinate judges court, according to the plaintiff, according to the state of Tripura, came via section 9 of the Indian Independence Act 1947. Apart from partitioning the subcontinent and granting independence to these two entities, India and Pakistan, the Indian Independence Act also made provision for ensuring that these kind of issues are dealt with smoothly, that there is no hindrance to the existing suits that were being heard by the various courts across India, which involved these parties which now were going to be part of different nations altogether. Section 9 of the Indian Independence Act gave the Governor General the authority to pass any orders for bringing this act into force. And 91D is, let's just look at it. This is section 9 of the Indian Independence Act. It's surprisingly difficult to find the original text of the Indian Independence Act, by the way. An act passed by the Parliament of the United Kingdom. So 91D, the bottom line on this page, is a bit of a catch-all provision. The Governor General shall by order make such provision as appears to him to be necessary or expedient for removing difficulties arising in connection with the transition from British India to either India or Pakistan. So it was argued on behalf of the state of Tripura that the order passed by the Governor General under 91D, that order happened to be the Indian Independence Legal Proceedings Order 1947. This order ensured that the province of East Bengal would continue to be the respondent in this case, and the case would continue to be heard by the Alipur court, although it was a court in India and not in Pakistan. Article 4 Clause 1 of the Indian Independence Legal Proceedings Order 1947 states that all proceedings pending in any court in Bengal, Punjab or Assam, the provinces which got partitioned, shall be continued in that court, and that court shall continue to have all the jurisdiction and powers which it had for the said proceedings. It seems quite straightforward over here, and based on this 4.1 article of the Indian Independence Legal Proceedings Order 1947, that the Alipur court ruled that obviously the province of East Bengal would be subject to the jurisdiction of the Alipur court after partition, because it had been a party to a suit which had been filed before partition. So, read with section 9, that order gave the Alipur court sufficient jurisdiction That is what the Alipur court ruled, and so the suit should continue in the Alipur court in Kolkata in West Bengal, although a party to the suit was the province of East Bengal. East Bengal decided to appeal this particular order of the Alipur court. Section 115 of the Civil Procedure Code allows for seeking a revision to the High Court, and the Calcutta High Court under this petition reversed the decision of the Alipur court. The Calcutta High Court ruled that the Alipur court did not have the jurisdiction to hear the suit. What were the reasons behind that? The argument successfully made before the Calcutta High Court by the province of East Bengal was that this substitution from Bengal to East Bengal would be valid only as per the provisions of a different order passed under Section 9 of the Indian Independence Act. This order was the Indian Independence Rights, Property and Liabilities Order of 1947, Section 12 of which allows the substitution of East Bengal to East Bengal instead of Bengal only if some right or property or liability of Bengal was being transferred to East Bengal. And since there was no right or property or liability being transferred from Bengal to East Bengal in this particular situation, the substitution of the defendant from Bengal to East Bengal was not valid. The right to tax passed to East Bengal as per Section 18 of the Indian Independence Act and not as per the Indian Independence Legal Proceedings Order 1947. That was the claim that was made before the Calcutta High Court, and the Calcutta High Court agreed with that. Section 18(3) of the Independence Act says that the law of British India and parts thereof existing immediately before 15th August 1947 shall continue as the law of each of the new dominions until other provision is made by the laws of legislature of dominion in question. This meant that the right to tax passed under this section, this provision, and not under that legal proceedings order. So instead, as it said, it was passed under the Indian Independence Rights, Property and Liabilities Order. So, as if the matters were not complicated enough, we are now introduced to this second order passed by the Governor General. This was the Indian Independence Rights, Property and Liabilities Order of 1947, and Section 12 Clause 2 of that order states that where any province from which property rights or liabilities are transferred by this order is immediately before the transfer a party to legal proceedings with respect to that property or those rights or those liabilities, the province which succeeds to the property rights or liabilities in accordance with the provisions of this order shall be deemed to be substituted for the other province as a party to those proceedings. So basically what this in a convoluted fashion is stating is that only if legal rights or liabilities or property is transferred from Bengal to East Bengal, only then you can substitute East Bengal as a respondent in this particular suit. And since no rights liabilities are transferred, was the claim being made, East Bengal cannot be a party to this suit, and therefore the Alipur court does not have jurisdiction to this particular suit. The Calcutta High Court therefore agreed with this particular discussion, and the state of Tripura was left with no option but now approach the Supreme Court of India, which had by now come into existence. And this approach to the Supreme Court, by the way, had come via an approach to the federal court. That particular federal court jurisdiction was provided for by the Government of India Act 1935, Section 205, Clause 1 of which allowed the High Court to give a certificate of appeal This appeal was made to the Federal Court of India. The Federal Court of India was succeeded by the Supreme Court of India on 26th January 1950, or 28th to be precise, when it was inaugurated, as we have seen in one of our earlier videos. And that is how the Supreme Court of India came to hear this particular case. Let me remind you, what is being heard is only whether the Alipur court, subordinate judges court, has the jurisdiction to hear this suit at all. What is going to be actually decided by the suit, whether the agricultural income of a princely state is taxable by the province of Bengal or East Bengal, that is not in question at all. That will be heard later on. But which court should hear that is what is being discussed. And we have already spoken for almost 25 minutes. It is, as I said, a complicated, convoluted case, but a fascinating one nonetheless, an intriguing one, and a landmark one. But we are coming to the close of this, because now, with a 4-1 majority, the Supreme Court ruled in favor of the state of Tripura, stating that the suit between the state of Tripura and the province of East Bengal can indeed be heard by the court of the subordinate judge of Alipur. Chief Justice Kanya, Justice Patanjali Shastri, Justice B.K. Mukherjee, and Justice N. Chandrasekhar Iyer, a new judge for us. He succeeded Justice Das, S.K. Das, having retired. Justice Fazal Ali dissented in this case as well, just as he had in the cases of Romesh Thapar and Brij Bhushan several months ago. Nonetheless, a 4-1 majority, the judgment was written by Justice Patanjali Shastri on behalf of those 4 judges. Fazal Ali dissented and wrote his own opinion, which is very interesting as well. The matter before the Supreme Court, it basically turned on this particular section, section 10, subsection 2, clause A of the Indian Independence, Rights, Property and Liabilities Order. What was going to be decided was basically on the question of whether or not any right or liability or property had been transferred from Bengal to East Bengal. If it had, then East Bengal will be substituted for Bengal in this particular suit. If it hadn't, then East Bengal cannot be substituted in this particular suit. The Calcutta High Court had ruled that East Bengal cannot be substituted because no right, liability or property had been transferred from Bengal to East Bengal as far as this suit was concerned. The Supreme Court ruled that such a transfer had taken place. The reliance was on this clause, where the province of Bengal is subject to any liability before 15th August, that shall be a liability of the province of East Bengal if the cause of action arose wholly within the territories of East Bengal. There was no doubt that the cause of action arose entirely in East Bengal. The notice for income tax assessment was sent by the Dhaka income tax officer for properties held by the state of Tripura in the Komila range, that is where that estate of Chakla Roshnabad lay. So the cause of action did arise in East Bengal. Now it was only whether or not it was a liability. The argument made before the Calcutta High Court, the successful argument, was that liability only talks about tortious liability. If the province of East Bengal was involved in any action of tort. That argument was not accepted by the Supreme Court. The Supreme Court ruled that the initiation of assessment under that Bengal Agricultural Income Tax Act 1944 was indeed a liability as per section 10(2)(a) of the Indian Independence, Rights, Property and Liability. Therefore, substitution of East Bengal for province of Bengal in this suit can be done as per section 18 of that same order. Therefore, East Bengal will be a party to this suit, and because a suit filed before partition could be heard by the court under which it was filed even after partition, therefore the court of subordinate judge Alipur has the jurisdiction to hear this particular suit. That is what state of Tripura versus province of East Bengal was all about. That was the decision of the Supreme Court. What actually happened? Did the state of Tripura win this particular case? That is not under discussion over here. What is only being decided is whether a court in India could adjudicate over a suit involving a province of Pakistan. And in this particular situation, because of all of these complications, the Supreme Court ruled that yes, in this particular case, it was possible as per the enactments and the orders made under those enactments, under the Indian Independence Act and under the Indian Independence Legal Proceedings Order and the Indian Independence Rights, Liabilities, Property Order as well of 1947. A fascinating case, a wonderful case if you are arguing as a lawyer. Plenty of issues and plenty of possibilities and permutations to be taken care of. Hope you enjoyed this video. I accept that it has been a very complicated case and I have tried my level best to make it as simple as possible. And in the next videos, we will look at one of the most important early judgments of the Supreme Court, that is Champakam Rajan versus the state of Madras. Hope you join me then as well. Thanks for listening. Have a good time. Take care of yourself. Bye bye.